I'm Drew Stevenson, and this is a lecture for my administrative law class about the Freedom of Information Act and specifically about FOIA procedure. Now, for my students, remember, all the real action about FOIA is about the 9 exemptions and that agencies will invoke so that they don't have to turn over information when they get a FOIA request. It's worthwhile, though, to do just a quick overview about some of the statutory procedural rules so that you're aware of them. And keep in mind that agencies get to set a lot of sort of the specific nuts and bolts rules about how they will handle and process FOIA requests. So this is just supposed to be a quick overview about the procedure, and this is located in the Freedom of Information Act, these rules for the most part. I will also reference a couple of recent US Supreme Court cases that pertain to this. So first, how long does the agency have to decide whether they're going to comply with a FOIA request? And the answer is the agency has 20 working days, so we don't count weekends or holidays, to inform the requester of its decisions to grant or deny access to the materials. And if access is granted, it must occur promptly thereafter. In other words, you can't just put the person off indefinitely. Can an agency charge fees? And the answer is yes, maybe. It depends on who's doing the FOIA request. So agencies are allowed to charge for doc review in addition to search and duplication costs if the records are requested for commercial use. So just a couple quick things to explain here. First, it's not just, even though FOIA was originally sort of conceived with the idea that reporters needed to get government information and have more transparency in government, and researchers at universities, professors, scientific researchers who need data that's collected and collated by the federal government to track, let's say, trends and climate change trends or something like that. This would all be very useful. But there's also a lot of people just in the corporate sector who find the information, especially from the agencies that regulate them, to be very useful. And so sometimes people will do a FOIA request, get the information, and they intend to sort of recompile it or repackage it and sell it to parties that would consider that information really useful and valuable. So that's what we mean by commercial use. When we talk about review, remember that you're going to get a FOIA request and the agency has warehouses of archived documents and things like that. And so it can take time. It's going to be labor intensive to sometimes to fulfill the request, and they can't just do it in one day typically. Sometimes it can take months. And then so they are going to have to find it, that's search. And then there's a little bit of document review you have to do for two things. First of all, you have to redact out private or personal information or classified information and things like that that you're not supposed to disclose. And also, sometimes you have a whole box full of documents and you have to go through them one by one and figure out which ones fit under the FOIA requests and which ones don't. And that can take a long time to actually look at the document. And so for non-commercial requests, specifically by the news media or educational or scientific organizations, so that would include university professors, the agencies can only charge copying fees. And then we have an in-between category of non-commercial requests. So this would be like citizen advocacy groups or nonprofits like the ACLU or the Sierra Club. They can charge the agency can charge not only duplication fees, but the search fees, but not for document review. Also, keep in mind, agencies can and sometimes do choose just waive the fees. Can anyone request documents under FOIA? The answer is yes. The language of FOIA does not appear to limit who can request documents, but keep in mind that not only does the federal government have a Freedom of Information Act, every state has some version of a Freedom of Information Act, and some of those states have limit basically their state FOIA request of the state government to citizens of their state. And the Supreme Court has upheld states having citizen-only provisions in their state versions. And an example would be 2013 McBurney v. Young, where they upheld a citizen-only provision in Virginia's FOIA statute. Must a requester identify specific documents in a request? No. FOIA merely requires that the request reasonably describe the record sought. So you can't just ask for everything that an agency has. You have to specify it a little bit, give them something to work with, but you don't have to identify documents precisely as part of your FOIA request. Here's another side note. Under the Freedom of Information Act, agencies have to publish in the Federal Register descriptions of structure and operating procedures, substantive rules and interpretations, and the methods by which the public can obtain further information from the agency, according to the APA. So some of the things about how the agency works, like its org chart and some of its substantive rules and so forth, they actually have to publish in the Federal Register so it's available to the public. So you can learn a lot about an agency without even doing a FOIA request. And then you also have to publish things about information about how the public can submit FOIA requests. Now, what about the records? Are all the records located on an agency's premises considered agency records for purposes of FOIA? And the answer is no. For purposes of FOIA, there are two requirements that must be satisfied for requested materials to qualify as agency records. In other words, the agency, not everything that the agency has, every piece of information or document, is actually subject to the Freedom of Information Act. So first, the requested materials must have been created or obtained by the agency in the course of performing their official duties. And secondly, the agency must be in control of the requested documents at the time of the FOIA request. So if the agency no longer has the documents, then they can't divulge them. And also they may say that they didn't actually create the information. They may have obtained it from someone else or just be holding on to it. What about government-funded studies? So there's a number of studies that, like the CDC, that will commission scientific studies and fund them. And there's grant-making agencies that fund scientific research by universities and so forth. And if the government gives you a research grant from the National Institute of Health or the CDC or other agencies, let's say the FDA, they are usually entitled to a copy of your research. So government-funded studies do come under FOIA's requirements, but only if they are actually received and retained by the agencies. Otherwise, they do not qualify as agency records under FOIA. Also note, even if the agency has a right to obtain the records under the terms of a research grant that it extended to a private party, the records are not agency records unless they're in the agency's possession. And so sometimes the agency, when they make a grant to, let's say, a researcher or research university, will say that they're entitled to a copy, but then they never follow up and get it. And so if the agency doesn't actually have it in hand, they don't have to go get it for you when you submit a FOIA request. There's some definitions here that are worth noting. FOIA uses a broader definition of agency than the rest of the Administrative Procedure Act. And it includes agencies that therefore are not really subject to the rest of the APA, such as government corporations. So if you're wondering what is a government corporation, you should think of things like the Legal Services Corporation, the LSC or the FDIC and so forth, or executive branch entities that exist just to gather data. Warning, here's another fairly recent US Supreme Court case from 2013. You can get in trouble for what you do with the information that you get through a FOIA request. So keep that in mind. The fact that you submit a FOIA request doesn't mean everything's good just because there was no FOIA exemption. And in this case, Mirasic v. Spears, Lawyers used FOIA requests, a series of them, to get personal information about recent car buyers in their state from their state Department of Motor Vehicles, or DMV. And what they wanted to do was send these people letters asking them to join lawsuits against car dealerships, knowing that they had recently purchased cars. This actually violated another federal statute, the Driver's Policy Protection Act, or DPPA, by obtaining and using individuals' personal information from motor vehicle records for bulk solicitation without their express consent. And so keep in mind that even if the agency has to turn over the information under FOIA. And what happened here was they used the state FOIA rules as opposed to federal to get this information from the South Carolina DMV. But their use of it to kind of send solicitation letters violated a federal statute, the Driver's Privacy Protection Act. Now, I don't want to get too much further into this case. There is an exception in the act, and the lawyers were saying that they came under the exception, and the Supreme Court said that they didn't. So therefore, they were liable under this act. So just be aware that there are a number of state and federal statutes about what you can do with information that you obtain from the government. So be careful. Okay, that concludes our quick introduction to FOIA procedure.